Yeah, thanks for having me. So I'm Austin. I run a digital compliance automation company called Leica. We basically help predominantly technology companies automatically verify their compliance with different cybersecurity standards and privacy standards like SOC 2, ISO 27000, HIPAA, high trust, the list goes on and on. But we essentially help them get audited and demonstrate those compliant operating protocols to regulators, enterprise buyers, and different industry bodies.
Great. So this topic is called avoiding landmines. The reason we called it this is that if it hasn't been clear so far, this industry is riddled with landmines. There is a prize, there's a there. It's something for us to all be excited about from a demand perspective. But I think a lot of the companies that have gotten tripped up to this point have stepped on a landmine or two of one type or another. And I'm not going to take time to dive into all the ones that have happened in the past. What we're here to talk about right now is a future landmine that I think Austin and I see and are concerned about and think it's really important for us to talk about here. So we're trying to bring more sophistication to this industry and usher this industry into the mainstream. Austin, what can you tell us about data compliance and what the average cannabis company should be thinking about when it comes to data compliance?
Yeah, so I guess taking a step back, I didn't come to be intellectually curious and commercially interested in digital compliance overnight. I previously ran a data science company, which had nothing in principle to do with regulation, and bringing our products to market meant selling into big enterprises, Johnson & Johnson, CVS, Doximity, Intuit, PayPal. These types of organizations put us through an incredible rigmarole with respect to assessing our security and data privacy practices. That inspired me to start this new business, and we have found great success with a number of different notable cannabis technology providers. And I think like there's just a huge gap in tools, both financial tools and technical tools, to serve every type of stakeholder in the cannabis space. And those technology companies that are entering to fill those gaps they're subjected to all of the stuff we've been hearing for the last 2 days with respect to cannabis regulation.
Yep.
But they are also subjected to all of the same digital compliance requirements that any ordinary software company is encountering these days. And it's like really proliferated in the past few years. If you're employing one software engineer and you're holding any data, chances are you are subjected to some rules that you may not know about, and that could cause you problems.
Yeah, so I'd love to hear, what are some examples of that? So we're basically saying that there's a whole other set of rules and regulations that most cannabis companies probably aren't thinking about. And it sounds like you do have some customers who have come to that realization that they actually do need to be thinking about it and paying attention to it. Name names or not, but maybe functionally speaking, where has that need cropped up?
So a lot of our cannabis technology customers are operating at the intersection of some other domain, like POS systems are operating at the intersection of cannabis and payments. We have a number of banking platforms are customers of ours. They're trying to equip one case credit unions with all the tools they need to be comfortable serving the large number of dispensaries that represents a huge audience that they're just not able to serve today. And so the customers that have come to us have come from cannabis in a certain regard, but they are finding us at a moment where their business's ability to grow and to partner with a bank or partner with a card issuer or to partner with an insurance provider includes all this new digital compliance stuff that they've never even heard of. A lot of them have never, I think most know that if you're holding patient data, there's this thing called HIPAA. They have no idea what it is. And most will have not heard of things like SOC 2, which is a widely adopted enterprise standard for auditing information security and data privacy practices. You can produce a report and represent that you're SOC 2 compliant. Like a lot of our customers come to us, they're like, I never even heard of this SOC 2 thing, but I need it because JP Morgan asked me for it and I really want to do business with JP Morgan.
Yeah. So I think a lot about this is about facilitating trust. And you and I have talked before about, cannabis is trying to facilitate trust between those who are interested in cannabis and getting them safe and consistent products. But really what we're talking about here is a whole nother level of trust facilitation. What do you think that cannabis companies can adopt or learn from the broader market as far as like how to facilitate that kind of trust?
Yeah, so just generally speaking, technology providers are coming under way more scrutiny. Like there's just open the Wall Street Journal any day of the week and find, a new misadventure in technology. Like there's a maturing that's happening across the board with respect to big companies scrutinizing just how much risk am I taking on if I bring this piece of technology in-house. That is exacerbated tenfold when it's a cannabis company, because cannabis providers are already in business trying to prove to the mainstream world that these are safe products, these are life-saving medicines, and it's an uphill marketing challenge, as everyone in this room knows. Paying attention to this digital compliance stuff early, I think, is important, because there's only you guys can solve the cannabis maturation or perception problem. But once you've done that, don't you want to be able to step into the mainstream without yet another array of challenges that you could get blindsided by if you're not anticipating it?
So just to wrap our heads around this, what would be the cost of if I'm just going to ignore data compliance, some of the acronyms that you talked about, SOC 2, HIPAA? Is that a nice to have, or what kind of risk am I taking if I'm not actually paying attention to these things?
So you can think about it in a number of different ways. Like in one sense, it's a go-to market problem. Like if you emit the semblance of a risky, small cannabis-related technology provider, you're not going to attract the eyes of any mature organization to strike a banking partnership. And so you can think about all of the lost opportunity that you might have seen had you had the right compliance stickers on your website, had you been able to furnish the right documentation about resiliency and fail. And so in that sense, it's sort of like, it's how many missed opportunities could you have otherwise closed deals with, and that's a big unknown. You can also think about it in terms of the sort of downside. Like what happens if you're accidentally or deliberately doing something that's outside of a particular regulation? Say, California is leading the charge with data privacy in the United States. They've passed a bunch of legislation that is designed to protect consumers' rights, and it spells out all the things companies are obligated to do if they're holding a significant number of personal records for California residents. And this will all trickle down, by the way, across the states. It just happens to be in California where they're getting it started. The fines are severe. It could be between $2,500 and I think $7,000 a record. So
a record,
right? If you have a file with 20,000 California residents that's out of compliance, and you get caught. The math gets a little out of control.
So let me play devil's advocate. What if I'm an operator not in California? I hear of something like GDPR, which is a consumer privacy protection law in place for California. Can't I just ignore that? Or is there a risk to doing that if I'm, say, in Massachusetts?
Software doesn't have boundaries, really. Like these data breaches, they proliferate right overnight when they happen. So like whether or not you're operating in California or in Germany or wherever, like eventually the data gets out, and you can roll the dice and hope that whoever gets sued or prosecuted on those transgressions are others instead of you. Like lots of people handling data. There's an incredible number of, derivative data holders along the chain of custody, and any supply chain. We've heard like constantly this whole 2 days.
Those that are in a particular state where this applies. I'd like to get a little bit more detailed as far as what do these actual acronyms mean? Like if someone is SOC 2 compliant, can you explain a bit about what exactly that means?
Sure. So SOC 2 is a collection of reports that are produced as part of an IT audit. You have a couple of different dimensions that are at your option to include in the scope of the audit, but things like data privacy, information security, resiliency, that's, if you had a total failover of your application, how quickly can you get it back up? Your practices with respect to breach notification and generally like breach handling. And the idea of going through a SOC 2 audit is sort of born from the tradition of financial audits. You have an outside third party come in, systematically test your controls. And instead of testing your financial controls, you're testing your systems controls. You're testing your organizational controls. Are your people trained on how to destroy data, how to fulfill a request from a consumer for access to their data? All of those types of things, an auditor will systematically test. And they'll be looking for proof over the course of, usually it's like a 6-month operating period. So they're not just looking at your AWS configs once, they're looking, all right, show me as of a given date, all of your engineers and all of the code that they pushed, and prove to me that the code that they pushed had gone through a code review. There's many, many examples like this, like everything from 2-factor authentication to encryption provisions in certain databases, and on the list goes. And then at the end of the audit, you get to represent that your organization is SOC 2 compliant, which is one of the first things that an enterprise will do if they're contemplating a relationship, whether you're trying to sell to them or partner with them, is they'll look at what security standards are you complying with. And it can be a huge leg up when you're trying to get a new relationship off the ground with a company with a brand of consequence.
And the risk there is you would like to do business with a giant tech company and you are a cannabis tech company, or you would like to finally get some new banking services or what have you. Is it that the bank or that big non-cannabis tech company, do they look at non-SOC compliance as like, is that a red mark that is like you're tainted, and is it there's no way we'll work with you, or is the bar raised? How does that kind of work?
It depends on the particular organization. For some organizations, they just have a policy. All of our software vendors must be SOC 2 compliant. That is definitely a trend that we've seen increase in the past year or two. Other organizations will view the SOC 2 as, okay, this vendor is at least doing some stuff that we're going to care about. Let's run a pilot, or let's start the relationship small, and then we'll still have to do our own vetting on top of it. Having a SOC 2 or similar certification, it can never be a bad thing, right? It's only additive. It only increases the perceived and actual maturity that outsiders will view your company.
Yeah. So to take it back to cannabis, I think we've heard a number of instances of, let's say, customer list sharing. This brand has these customers, push them to this dispensary. This dispensary wants to make more money from a brand, and a little bit of sharing in one direction or the other. Can you explain a bit about, from your perspective, where there might be some problems that might pop up from that?
So I'll caveat by saying I'm not a compliance expert, and I'm certainly not in the weeds on the exact legislation. But the spirit of CCPA, just to take that as an example in California, it basically says you have the right to use the data that you collect primary And you also have the right to share that data, provided you explicitly tell the consumer that you're sharing the data, which data you're sharing, and with which party you're sharing it. And it has to have
All those things have to be true.
correct. And then that party only is able to use the data for whatever the explicit contract is between the collecting party and then themselves. So, I think there's a little bit of playing fast and loose with the back and forth sharing of data. And I mean, you're only subjected as an organization to these rules if you're big enough. You have to handle a certain number of records in California, or you have to be of a sufficiently large revenue size. There's a bunch of different variables that may put you in a position where you don't have to comply. But again, it's by nature of the way that data is. Like, you could go from not needing to comply with these rules overnight. You have a blockbuster month or something, and all of a sudden now you have crossed the threshold after which you're now subjected to the rule.
So another theme that I think is no longer, let's say, a secret is that there is an expectation of more consolidation, call it M&A, in the cannabis industry. How, if you were either an acquiring company, or maybe it's not as big of a deal if you're being acquired, but as an acquiring company in an industry like cannabis, are there data compliance considerations that one must be thinking about?
Yeah, big time. So my first startup, the data science company, we got acquired. This was a huge part of the pre-term sheet diligence process. We had to represent that what the company, Alteryx, the buyer, we had to demonstrate to Alteryx that what we were doing was up to their standards. And then now at Leica, just in the past year, there has been consolidation. One of our cannabis customers actually made 2 strategic acquisitions. Both were POS systems. Both had teams of between 20 and 30 employees. And yeah, absolutely. It was very important to choosing those targets, knowing that, or having a large degree of confidence that the targets were going to fit into their tech stack in a way that wouldn't, be tremendously risky from a technical perspective. And we've seen many other examples outside of cannabis. I think overall, your instinct on there being a very large amount of consolidation is dead on. There's just a lot of deals that got done in the past 2 years that probably didn't need to get done. And there's going to be roll-ups across the board, and that includes cannabis for sure.
Yeah, and I think the point there is, even if you're looking to sell your business, or even if you're in the privileged position of being able to acquire businesses in this industry or others, in both instances, you can be affected by whether or not your data is compliant, because ultimately that might come out of the price that someone pays for your business. If you weren't following the right rules and regulations, they say, this is a mess. Well, maybe we can still buy you, but it's going to cost us a lot of money. So what do you expect us to do about this, except for lowering the price?
Totally. It's a form of organizational debt. And any savvy buyer would 100% factor it in, just like they would, technical debt, big mess you have to undo and fix. Of course.
Great. Okay, so with that, open it up to questions.
Metrics do you use? Give us a little bit, but you can ask that what's going on or something. It's data, metrics do you start saying how to start considering.
I'll repeat the question.
Yeah. So the question is, how do you judge when it's the right moment in a company's growth to justify, from a business case perspective, investing in something like stock 2? I mean, look, first of all, it's far more cost effective to implement this stuff when you're smaller. If you're 300 people and you're retroactively injecting all of these compliant operating protocols, new programming standards, there's a cultural hit that you take, versus if a 10-person company you get everyone in a room, you sort of adjust a few things. You're just far less complicated when you're small. And so I think that there's some part of the answer has to do with, do I want to pay 300 grand in the future, or do I want to pay 15 grand now? And then I don't know about you, but like when I have a deal on the line and somebody says, great, send me over your SOC 2 report, I literally want to just say, wonderful, it's on the way. There's just, if you're being asked for demonstrable compliance 1 or 2 times, you're probably not getting asked by a dozen other companies that took one look at the website, they check out LinkedIn, they see how many employees are there, they see how long you've been in business, and they just say, no, we're not, this is just too risky. We better, find another provider. Like that's the scariest problem of all. It's like the missed opportunities because of a perceived immaturity level. And I think investing early in demonstrable compliance like a SOC 2 or an ISO report is like a great way to make sure that your name is in the hat when people are running RFPs or searching for partners.
You find on that team being go to market and going after your customers, do you find there's not just in cannabis but outside, do you find customers are picking up if you're type 1 versus type 2 with SOC 1 or SOC 2?
So the question was, what are we seeing with respect to SOC 2 type 1 and SOC 2 type 2? So the SOC family of audits has 2 different flavors. A type 1 is basically the auditor is testing that the controls are in place, that as of a given day, you have these security settings, you have these 2-factor authentication.
Single point in time.
The type 2 is the far more robust one, and that incorporates testing random data over a period of 6 months. Honestly, usually you only do the type 1 one time, and it's in your very first year, and then every other audit is a type 2. It depends. Like, I think you can get by with the type 1 that first year, really, unless you have a big enterprise customer who's insisting, like, I'm not going to buy your product unless you show me a type 2. Type 1's fine most of the time.
Yeah, when it comes to publicly traded companies, like when you're trying to sell into SOC 1 or SOC 2, which one do you think is going to assist more? Obviously, best at both, but publicly traded companies really.
So the question was, what about the SOC 1 audit versus the SOC 2? To add additional complexity to this story, the SOC family has a SOC 1 type 1, a SOC 1 type 2, SOC 2 type 1, SOC 2 type 2.
They got to come up with a different name.
The SOC 1 basically is an important report if whatever your software does handles money. If your software can influence the balance sheet of your customer in some way, probably you should get that in addition to the type 2. The type 2 governs, for the most part, just general security practices, general data protection practices, resiliency, things that have nothing to do with money being moved around.
We're at time? Okay, all right. Well, we got one more. Maybe time for one more.
Sorry. So this is kind of my interesting perspective on this. So like one thing, as of just like relative sophistication cannabis operations, like for example, a lot of people say, "Are you HIPAA compliant?" You say, "Yes, we're happy to sign a PA," and then they go, "What is that?" And it's fairly been like, oh, we need to go after forcing things.
Not yet. Not yet.
So I'm just interested in what you think in those kinds of conversations, where a lot of time what we're dealing with is a lack of just pure knowledge of what security standards are for enterprises that, perhaps shouldn't be given to them, but as someone selling to them, what do you believe is the obligation on either the software provider, the regulator, or customer to be able to know this information?
Yeah, I mean, just like in cannabis, like the regulators in, and by regulators, I generally mean also like the non-regulatory standards, but the ones that are increasingly non-optional, like PCI is the payment card industry's compliance standard. Like all of the standards trail the innovation. And so there are these funny moments where like the enterprise may not fully understand all of the technical things that they're indeed implicitly asking you to demonstrate. It really doesn't matter. Like if Yale New Haven Hospital has a policy, like you gotta conform to the policy. If the state of California has a policy, you have to conform to its policy. I would wish regulators would stay ahead and, you know, keep up faster, but I think it's just like any of these other domains, just like cannabis, frankly.
Great. Thank you.